Hawker Pacific was hired by Helicopter Charter to paint 2 helicopters used in Helicopter Charter's business. There was a price agreed and the painting proceeded. Helicopter Charter were not happy with the painting works done on the helicopter. They refused to pay, and the choppers went back to Hawker Pacific for some further painting. The agreed price was reduced. Helicopter Charters were still not happy, and the helicopters went in for a 3rd time to have more works done at Hawker Pacific's expense. After that 3rd round of painting, the manager of Helicopter Charter and one of the pilots arrived to collect the helicopter. They were in a bit of a hurry because the chopper was needed for a charter that day. Hawker Pacific, however, had other ideas. They were careful not to make any explicit threats, but at the same time, they made it clear that the helicopter wasn't going anywhere unless Helicopter Charter signed a document stating their agreement to now pay for the paintworks. Helicopter Charter had no choice. They needed the helicopter that day, and so they signed. But they were still unhappy with the painting, and the whole mess ended up in court, where the New South Wales Court of Appeal had to determine whether the agreement was in fact signed under duress. First things first, the court said it didn't matter that the threat was never expressly or explicitly stated. Justice of Appeal Priestley said, if circumstances for which the appellant was responsible conveyed the threat to the respondent, then the threat of duress would operate as forcefully as if it were put into words. Then the court went on to find that making threats against someone's goods or possessions is duress, just as much as if those threats were made against the person themselves. Justice of Appeal Priestley noted, the respondent was entitled to take away its helicopter. Hawker Pacific's conduct showed, and Helicopter Charter's manager believed, that Hawker Pacific would not permit it to be taken away unless the respondent did what the appellant wanted. It was clear as a result that if one person holds another person's goods illegitimately, in circumstances where the owner should be entitled to just take those goods away, and if the purpose of doing so is to force the owner into an agreement, the contract will be made under duress and will be unenforceable.